So now, ladies and gentlemen, uh, I have tried to explain uh, who are the preemptors. I have already pointed out that out of the three classes of the preemptors, only two are recognized under the current law, that is, right of the preemption is available only to the co-sharer, right of the preemption is available only to the participator in the appendix and immunities. But right of the preemption is not available to the third class of the owner, that is one who is only the neighbor. So on the basis of the neighborhood, one cannot claim the right of the preemption. It has been held by the Supreme Court in a case that is Abdul Razak Sajan Bagwan versus Ibrahim Haji Muhammad. In this case, the Supreme Court has held that right of the preemption can be claimed on the ground of Safi Sharik or Safi Jar having the property adjoining to the suit property. The Supreme Court held that law preemption based on the business was wide and unconstitutional, and therefore simply on the ground of the neighborhood one cannot claim the right of the preemption. For example, take the example. Suppose here they are the co-sharer. They are the co-sharer. The property there is in the co-ownership of A and B. Now, A has the right of the preemption against B in the event of the sale of the property by B to C. Now, suppose A and B are the owner and there is a common road leading to the entrance of the A, property of A and property of B. So, they are the participator in the appendage and immunity attached to the property of A and property B. So, they are Safi Khalid. And being the Safi Khalid in respect of their properties, A is entitled to claim the right of the preemption against the property of B, and B is entitled to claim the right of the preemption against the property of A because both are participator in the same immunity in respect of their properties. And therefore, the Supreme Court has recognized that one co-sharer can claim the right of preemption against the other co-owner. In the same way, if the two persons are related to each other by Safi Khalid, they are Safi Khalid, means both are participated in the same immunity. Then in the event of the sale by one Safi Khalid, other Safi Khalid will be entitled to exercise the right of the preemption, and this is also recognized under Muslim law. But now the rule is that if suppose there are two properties in the neighborhood of each other, one property is this and there is another property, say for example of this property, A is the owner of this, B is the owner of this, and both are in the neighborhood of each other. They are based properties are based on the businesses. Now here if A is selling his property without information to B, then right of the preemption will not rise. Here means the A can independently sell his property to anyone without even with information or without information, because they are not participated in the immunities related to their respective property. They are also not co-sharer. What is their relationship? In respect that they are simply the neighbor of it. This property is nearer to this property. A is the neighbor of B and B is the neighbor of A. Therefore, the Supreme Court in Abdul Razak Sajan Sahib Bagwan versus Ibrahim Haji Muhammad Hussain, EIR 1988, held that right of the preemption can be claimed only by the co-sharer are participated in the appendage immunities but not by the neighbor. And therefore, if two persons are mere own neighbor having the different properties, so here the right of the preemption does not apply or will not apply. So, Safi jar, that is, if two persons are simply neighbor of each other having the properties, then here right of the preemption does not lie. It does not lie. This has been clarified by the Supreme Court in Abdul Sazzaq Rajan Sahab case. Now, gentlemen, now I am going to discuss formalities for claiming the right of preemption. What are the formalities prescribed by Muslim law for claiming the preemption or right of the preemption? According to Hidayah, the right of the Sufa is but a very feeble right or weak right, as it is another property. In order to prevent the appended inconveniences for this reason, the law considers certain formalities as imperative. The Muslim law preemption is a law of technicality, and existence of the right depends upon the full and complete observance of the formalities. It is a ritual. If the ritual be defective, the claim will not emerge from this bottle. Unless the words are open, the door will not open. The ceremonies are in any way incomplete or erroneous. The right of the Sufa does not take the form but remains unsubstantial. It is a right that it should be so because the doctrine involves an interference with one of the fundamental human rights, that is the right of freedom of contract or sale. No person is entitled to the preemption unless he takes the proper steps at proper time and conforms strictly to the necessary formalities. And the necessary formalities are known in context of the right of the preemption as three demands. They are known as free demands, or demands are three demands. The first demand is called as Mowasibat, means as soon as preemptor has received the information about the sale of the property which was in his co-ownership, of which he is the co-sharer, then preemptor must assert, as soon as the information has come to the preemptor, immediately without any delay he must assert his claim immediately on hearing of the sale, but not before. For example, take the example, this is the property and this property in the co-ownership of A and B. A is the owner of the 50% and B is the owner of the 50%. They are the co-sharer in the property X. Now A has sold his share in this property to C for rupees 1 lakh. Now, and no information regarding the sale of this property was given by A to B. Rather, A directly approached to C and sold his share, which was in co-ownership with B. And a sale deed is executed between A and C, and it has become final. As soon as the sale has become final, and thereafter he is informed about the sale of this property to C by A. So as soon as rule requires that as soon as for the first time B receives the information that property A has sold his share in the property to C and sale deed has been executed. So after the execution of the sale deed, for the first time when he received the information, immediately on receiving the information, he must assert his claim that basically he was entitled to this property, he was entitled to purchase this property, why was he deprived of this right, and therefore immediately he should raise his objection or assert that I am entitled to this property and therefore first of all I should get it. Preemptor must assert his claim immediately on hearing the sale but not before. Witnesses are not necessary for raising the demand, not in any particular form. Now, simply that he can point out I have demanded or I demand the preemption is enough. Simply saying that I am entitled to the preemption, that will be sufficient. So immediately on getting the first time information, he should claim, he should assert his right. What is his right? That he was entitled to preemption. Preemptive right was he was having the preemptive right, and therefore he has the right to preempt into the shoe of the vendee, that is C, and thereby he is entitled to claim the property. So he should assert his right immediately on getting for the first time information regarding the sale of his a property which was in co-ownership after two persons. So formality is very strict, and any unreasonable delay will be constituted as an election not to preempt. A delay of 12 hours was in no case considered too long, and in another, the right of the preemption was denied to a man who, on hearing of the sale, entered his house, opened a chest, and in this way he delayed the demand. So, rule is that the Talab-e-Mowasibat or first demand for preemption should be made or asserted or raised as soon as he has got the first time the information regarding the sale of a particular property. If after receiving the information he waits for some time, or he is lethargic and did not respond to it, then this will be unnecessary delay, and on this ground he will be entitled to lose this right of preemption. Therefore, the first demand for claiming the property back in the exercise of the right of the preemption should be made without any delay, without any further delay, and this will be called as first demand claiming the right of preemption. Then he should make the second demand, Talab-e-Ishhad it is called. The preemptor must with the least practicable delay make a second demand. Means say for example first demand was made on a particular date on 1/1/2024, and after first demand there is no any response from the vendee as well as the vendor. Then after a considerable lapse of the time, say for example after 2 days, again he can raise a demand, similar type of the demand, and that will be called as second demand. So the preemptor must with at least practical delay, a reasonable delay, should make a second demand. He must refer to his first demand, means reminding the first demand he should make the second demand after a reasonable delay. Do so in the presence of either the vendor or the purchaser or on the premise of his known Talab-e-Ishhad. This is known as Talab-e-Taqreer. The demand of means he should go after first demand, directly he can go on the spot of the property, and on standing on the property in question, he can raise the demand that already I have made the demand for the giving back this property to him in the exercise of the right of the preemption. After a reasonable delay, he in order to show that he is so much interested, he can go even directly on the spot to the of the property, and he can demand this make the second demand for the property, that is known as Talab-e-Ishhad. A common form of the demand is the pre-emptor says such a person has bought such house of which I am a pre-emptor, I have already claimed my privilege of pre-emption, but and not now, again I claim it, be ye witness thereof. The property must be clearly specified by the pre-emptor. If the pre-emptor is at the distance and cannot be personally present the second time demand, the second demand may be made by any agent authorized by him, or even by a letter, or on omission by agent will bind the pre-emptor. Tender of the price is not necessary, provided that he offers to pay the or agreed price, and if that price appears to be fictitious, then such price as the court may fix. If there are several purchasers, the demand must be made to all of them unless it is made on the premises or in the presence of the vendor. If, however, the demand is made to some only of the purchaser, the pre-emptor cannot claim his right as against the other purchaser. Sometimes the first two demands may be combined, means first two demand, one the pre-emptor can go directly on the spot of the property, and standing over there he can make the first demand, and thereafter he can also raise the second demand, and in this way the formalities are complete. It is not necessary for the pre-emptor to enter the house and make the demand. It is enough if he goes if he goes near the house and by touching the walls of the houses makes the demand. This would be sufficient compliance with the legal requirements of second demand. Third demand, that is known as Talab-e-Tamlik. This is called as third demand. Third demand is not really a demand but taking the legal action. Means after first demand, if there is no response, then second demand will be made. After first and second demand, if then the pre-emptor will be entitled to take the legal action, and it is not always necessary. It is only when his claim is not conceded or accepted that the pre-emptor enforces his right. Then the pre-emptor can enforce his right by bringing a suit, and it is not always necessary. It is only when his claim is not conceded that the pre-emptor enforces his right by bringing a suit. Such action is called as Talab-e-Tamlik or Talab-e-Khusumat, demand of possession or demand where there is a dispute. The suit must be brought within 1 year of the purchase. If no suit is brought after 1 year, then his right of preemption will cease to exist, will not be available to him. And therefore, if the necessary formalities of first demand, second demand and third demand are not fulfilled, or there has been slackness in fulfilling the demands, then that slackness or delay in exercising the right of the preemption will lead to the losing the right of the preemption. Therefore, the right of redemption is lost in the following three ways: omission to claim the waiver or excessive delay in the demanding it, death of the pre-emptor before the enforcement, forfeiture of right. Omission to claim the waiver, here it means a person entitled to preempt loses his right if he expressly or impliedly waived it. For example, he says, I have made white the sofa or have caused it to the drop or omits or to assert the immediately his right. Death of the preemptor. Under Hanfila, the right of the preemption is extinguished where the preemptor dies before enforcing it by suit, even if he made two demand. Under the Shafi'i and Shia law, however, the right of the preemption devolves upon the preemptor's heirs in proportion of their right of inheritance. The right of the preemption is forfeited in the following cases. A. The preemptor releases it for a consideration. B. It tries to dispose of the subject of preemption to a stranger. Partition is made. There is some statutory disability with the preemptor as the regard to the purchase of the land. For example, a Punjabi buys a land in Nagaland where the land cannot be purchased by a non-Naga. So here in this case, the right of the preemption will not. So this is all about the right of the preemption that I have discussed. With this, now I thank